Paul, let me start with a question for you. How many jurisdictions have adopted Restatement 3D?
Well, I think like Ann said, a lot of them are using it at one level, one degree or not, but I'm aware it's a handful, I think, where we have express adoption. And I think Ann is actually in a better position to give us a little more detail on that.
Ann?
Yeah, Paul's right. Express adoption is very limited, but a lot of states, more than half, over 30 states have imposed post-sale duties to warn, which are essentially taking the restatement factors and formulating them into a legal obligation in those states, even if they haven't specifically said, hey, we adopt the restatement.
Do you want to ask the question that you had for Paul, or you want me to do it, Ann?
I have a question. Yeah, I do have a question for Paul. I don't often have products that have actually been subject to a recall, but I have had products that the company has undertaken to do a retrofit. They've changed the guard, they've sent out the guard. Do you deal with that straight up with the jury, and do you include it in your opening?
So you're saying the injury is with the old product? The non-retrofitted
Well, the injury would be with the old, the injury is with the old product, unfortunately.
And in the meantime, you've come up with that's always right, a super big challenge, because products do evolve, and that's the whole point. One of the elements that evolve are going to be those safety. But I think you do have to take this, you have to take it on up front. But it's, the jury's going to look at you and say, well, you had this out there. You should have done something. And the question is, if you're talking about a true retrofit campaign, well, how did this product get missed? And that's where, again, what's your story? What's the explanation? If you're a defendant, it's not enough to just blow holes in the plaintiff's case. You've also got to have your explanation of why your defense makes sense for the jury. You've got to put the bow around it. But I think it's, if this was if it's a new design, you've now got an improved design, you try to keep that out, because that's going to, that's a huge 403 issue. And hindsight's 20/20 and all that kind of thing. I think that can definitely be highly unfairly prejudicial. And if it is,
sorry to jump in. I think just from the legal perspective, most of the case law trends towards saying that an improvement in a product design does not create any kind of duty regarding the former design. Just because something's better today doesn't mean that you have an obligation legally to go back to the former design and tell everybody about the new and improved. A retrofit is a little bit of a different wrinkle. The guard, people know that the guard is easily removed. They've come up with a way to fix it so that guard now stays on the machine permanently, or more permanently, nothing's permanent. That's a little bit of a different wrinkle. Probably courts, I think, would make the manufacturer responsible to do the best efforts that they can to contact the users. But I've had cases where users haven't gotten the word. A lot of machinery is sold through reconditioners and used dealers, and the company doesn't know who owns their thing anymore. It's been sold 3 times. It's a problem.
Right. And once warranties run out, and extended warranty, service contracts, maintenance plans, and the machine is just it's out of the network of the manufacturer or their distributors or their service people.